Hello, everybody, and welcome to the latest installment of Legal Bites, the official podcast of Cummings and Cummings Law, where our primary focus is on helping businesses and their owners re-domesticate out of volatile legal and tax environments to predictable pro-entrepreneurship, pro-growth jurisdictions like Florida and Texas. Today, I am reviewing a recent report by Caroline Petro Cohen for the LA Times entitled Yamaha is Leaving California After Nearly 50 Years. But before we get into that, a brief introduction. My name is Chad Cummings, and I am an attorney and certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. I am Chief Executive Officer of the multi-state, multi-attorney law firm Cummings and Cummings Law. And in addition to my day job, I also teach business and tax law at the university level. I hold 4 degrees, including 2 law degrees, together with a bachelor's degree in accounting and a master's degree in taxation, in addition to 11 professional licenses and certifications covering accounting, tax, audit, and of course, the law. My firm website is www.cummings.law. Now, Yamaha has been based in Cypress, California since 1979. That's 47 years. And recently, the company announced it is selling all of its California land, offices, warehouses, and fixed assets and relocating its U.S. headquarters to Georgia. The company said the move is one of its key measures aimed at improving asset efficiency and enhancing profitability in the United States. It cited cost increases from tariffs and changes in the market environment. But let's translate that to plain language. California is just too darn expensive, and the company can no longer justify remaining in the formerly Golden State. And Yamaha is not an outlier. It is the latest name on a list that has grown larger every quarter. The Los Angeles Times reported that Yamaha joins a wave of major corporations fleeing California, uniformly citing costly regulations and unfavorable business conditions. Tesla moved its headquarters out of Palo Alto in 2021. Charles Schwab relocated from the Bay Area to North Texas the same year. Elon Musk moved SpaceX and X, formerly known as Twitter, to Texas in 2024. Chevron, an oil company that was started in California, left for Texas in 2024. Public Storage left California for Texas in February 2026. Bed Bath & Beyond's executive chairman has said the company will not reopen any stores in California where it previously had more than 80 retail locations. He called California one of the most overregulated, expensive, and risky environments for businesses. The owner of In-N-Out announced she was moving her family from California to Tennessee, where she planned to open a new regional headquarters. She said, and I'm paraphrasing here, doing business in California is just not easy. And notice where these companies are going: Georgia, Texas, Tennessee, Florida, to name a few. These are states with no personal income tax or very low personal income taxes. California, meanwhile, has the highest state income tax rate in the nation at 13.3%, and that is not counting the proposed wealth tax that is being discussed in the California legislature. It is simply not competitive, and it has not been competitive for some time, and it is getting worse, not better. California, as I alluded just a moment ago, is considering a proposed wealth tax that would impose a one-time 5% levy on the net worth, not the income, but the net worth of high earners based upon their worldwide assets, not just their California assets. The pattern is unmistakable. Businesses are not leaving California because they dislike the weather. They are leaving because the cost of operating there, measured qualitatively and quantitatively in taxes, regulations, compliance burdens, and litigation exposure exceeds the benefits of remaining behind. And when a company like Yamaha, which has occupied 25 acres in Cypress, California for nearly half a century, concludes that selling every physical asset it owns in the state is the best financial decision, it tells you something about the trajectory of the business environment that no press release or tweet from Sacramento can contradict. This is where redomestication should enter the conversation. Yamaha is a multinational subsidiary with the resources to execute a multi-year physical relocation. Most small and medium-sized business owners simply do not enjoy that luxury, but most business owners do not need it. If you own an LLC, a corporation, or a partnership, you do not necessarily need to go through the same hoops that Yamaha has gone through to move out of California. All you need to do in many cases is change where your company is legally domiciled. Redomestication is the legal process of transferring the home state of an existing company from one state to another. You maintain your existing federal employer identification number. You keep your existing contracts. You keep your bank accounts. You keep your credit history. You keep your business name in almost every case. The company that exists after the redomestication is the same legal entity that existed before. Nothing changes except the state where the company is legally domiciled. It is a non-taxable reorganization under the Federal Internal Revenue Code when it is performed by a competent attorney, and that's a big caveat. Redomestication, when coupled with a change of personal residency and a reduction or cessation of business activity in California, can be an effective way to reduce or eliminate tax nexus in that state. For owners of pass-through entities like limited liability companies, subchapter S corporations, and partnerships where business income usually flows through to personal tax returns, these savings are not small. California taxes at rates between 10.3 and 13.3% on top of your federal tax. Florida and Texas tax it at zero at the personal level. Therefore, if you are a business owner earning, let's say, $500,000 in California, you are paying over $51,000 per year in state income tax that you would not owe necessarily in Florida or Texas. And over 10 years invested at 7%, that becomes over $750,000 in additional wealth. That is not a rounding error, that is a house. But here's the mistake many people make. They move their personal residence to a new state and leave their business domiciled back in California. Oops. California's Franchise Tax Board in Sacramento will continue to treat that business as a California filing entity. You will continue to file California tax returns forever. You will continue to pay the franchise tax forever. You moved your body, but you left your business behind. That is an incomplete move with serious financial and legal consequences. Now, let me briefly address three alternatives to redomestication and why these alternatives are usually inferior. First, let's start with foreign entity registration, which is sometimes referred to as foreign entity qualification, amongst other terms. Foreign registration keeps your company domiciled in California. You register in your new state, but you remain subject to taxes, filings, and annual reports in the old state. Now you are managing two compliance tracks, not just one. You save nothing on the tax side. You just doubled your administrative burden while remaining fully exposed to those variables that enticed you to leave California in the first place. Option number two, traditional merger. Now, traditional merger is still sometimes required in certain narrow circumstances for redomestication, but that is the exception and no longer the rule. There is a myth that California does not permit redomestication. That is a myth, as I just said. There's also a myth that California either does not permit redomestication of LLCs or does, but does not permit redomestication of corporations. Both of those are false. I mention this because so often I get onto the phone with the client and they start talking about merger. And I say to them, well, let's slow down. It's not 1996 anymore. There are alternatives. But anyway, I digress. Let me get back to option number two, traditional merger, and explain why that is usually unfavorable as compared with statutory redomestication. Merger requires forming a new entity in the destination state and merging the old company into it, by which the old company ceases to exist. You may need a new federal employer identification number. You may inadvertently trigger a taxable event. You will need to retitle assets, novate contracts, and establish new banking relationships. Legal fees can reach $10,000 to $20,000 or more for a simple merger. And if a single consent is missed or an assignment clause breaks, you have converted what should have been a simple exercise into a business disruption. Now, behind door number three, dissolution, and I hesitate to mention this as an option because it is really not an option for relocating an operating company. That is because dissolution, sometimes confusingly conferred to as termination. Well, really, those are two separate terms, but some folks mix them together, but we'll save that for another video for another day. Dissolution kills the company. There is nothing left to move. You lose your liability protection, you lose your credit history. If claims suffer after dissolution, as they so often do, those claims will land on you personally because the corporate veil no longer exists. Unless you are truly going out of business and shutting your doors forever, dissolution is not a relocation strategy and it should not enter the conversation at all. The most important document in a properly executed redomestication is the plan of conversion. It is a bespoke legal instrument. It is not a copy and paste template. Without it, your filing with the Secretary or Department of State may have no legal effect, or it may result in the unintentional termination of your company. I've seen that happen several times before we were brought in to correct it. Now, LegalZoom and Rocket Lawyer cannot prepare a plan of conversion for you because they are not attorneys and they do not owe you fiduciary duties. And as I have said in my earlier videos, while the advice from AI is starting to get better, it is still flat out wrong when you ask Gemini, GPT, Grok, or Claude about the redomestication process. My law firm handles this process for a flat fee in almost every case, and you can access exact pricing and complete the process on my website right now without waiting to speak to me. As an attorney, I personally prepare every document, file with both states in the correct order, and respond to any inquiries during the process, all while sending you weekly status updates by email until the process is completed. And I back it with a 120% money back guarantee. What that means is if the Secretary of State fails to approve your redomestication and I am not able to fix it, which to date has never happened, because I have a 100% success rate, I will refund 120% of your legal fees. If you have questions regarding redomesticating your existing LLC or corporation, please use the link in the description for more information on this intricate process and to schedule time for us to chat about your specific situation. Again, my name is Chad Cummings, and I hope that you found this information useful. As always, the information in this presentation is general in nature, and it is not legal advice because legal advice definitionally must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my earlier presentations, please visit my firm website at www.cummings.law to schedule time for that consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.